Hello friends. Today's topic is rights of minority shareholders. This topic is from company law. So before we talk about minority shareholder rights, let's understand who is a minority shareholder. Assume there is a company. Uh, there are three shareholders. One shareholder A is having 60% of the share, and the B and C shareholders have only 20% of each. That means 60 plus 20 plus 20, 100%. In this case, we can call A as a majority shareholder and B and C, uh, they have only 20% of share, right? They can be called as minority shareholder. So the Companies Act 2013 provides some sections to safeguard rights of the minority shareholders and remedies also. Yeah. Let's talk about the rights of the minority shareholders. There are actually five rights. I displayed it here. We can see it here. The first one is right to vote, voting right. So even though he is a minority shareholder, he is having the right to vote. Where in resolutions, generally in every company passes some resolutions, right? Uh, Frequently, it can be simple resolution, special resolution. So minority shareholders has the right. So these resolutions to appointment of a director, approval of final statements, financial statements, all these things, minority shareholder is also an active participant and he has a voting capacity. And the second one is right to receive dividends. Dividends are nothing but profits generated by any company. So even though the minority shareholders, they are minority in terms of shares, they are liable or they are entitled to receive dividends. This is very important, right? And the third one is inspect books and records. All minority shareholders or majority shareholders can always inspect books and records from the company. That is a right given by uh, Companies Law, Companies Act 2013 to all minority shareholders. And the fourth one is the right to call for a general meeting. There is a clause or there is a rule for this. Not everyone, not every minority shareholder can call for a general meeting. Only a person who is having more than 10% of share, then only he can call for a general meetings. So there is a specific clause for this particular right. And finally, if any person, any shareholder thinks his rights are infringed or oppressed, he can always reach out to NCLT in case he wants to get some relief from the management. The NCLT is nothing but National Company Law Tribunal, where they actually understands the problems inside the company and try to resolve them. So these five rights provided by Company Act 2013. There are remedies against oppression. So the remedies, section 241 to 246 of the Companies Act 2013 talks about the remedies against oppression by management to minority shareholders. So when anyone's minority shareholders right infringement, so they can approach NCLT for the justice. So there are like three key provisions or three key sections in this. First one is section 241, which talks about public interest. If any company operates against public interest, any minority holder can raise a dispute in NCLT. This is the section uh, promotes or defines. Section 241 allows any minority shareholders to raise any dispute against his company when the company is operating against any public interests. And the second thing is section 242. Now NCLT is our authority for company law. So NCLT can issue orders to regulate company affairs. So NCLT can regulate company affairs with by following rules and regulations specified under section 242. And third one is section 244. The eligibility criteria for making an application under Section 241 is defined under Section 244. The case law is Shanti Prasad Jain versus Kalinga Tubes Limited. This is a landmark judgment case where Supreme Court of India laid down the principles of determining what constitutes oppression, like what constitutes oppression and how to approach it. And Supreme Court gave some violations dealing how to share the dealing, how to share the standards, conditions of a fair play. Every shareholder is entitled to with them. Thank you. Please subscribe Nyaya Vidya.